Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in THRYV Incorporated versus Click-to-Call Technologies. Certiorari to United States Court of Appeals for the Federal Circuit. Argued December 9th, 2019. Decided April 20th, 2020. Inter partes review is an administrative process that permits a patent challenger to ask the U.S. Patent and Trademark Office to reconsider the validity of earlier granted patent claims. For inter partes review to proceed, the agency must agree to institute review. See 35 U.S.C. Section 314. Among other conditions set by statute, if a request comes more than a year after the suit against the requesting party for patent infringement, an inter partes review may not be instituted. Section 315b. The agency's determination whether to institute an inter partes review under this section shall be final and non-appealable. Section 314d. Entities associated with petitioner THRYV Incorporated sought inter partes review of a patent owned by respondent Click-to-Call Technologies. Click-to-Call countered that the petition was untimely under Section 315b. The Patent Trial and Appeal Board, hereafter Board, disagreed and instituted review. After proceedings on the merits, the Board issued a final written decision reiterating its Section 315b decision and canceling 13 of the patent's claims as obvious or lacking novelty. Click-to-Call appealed the Board's Section 315b determination, treating the Board's application of Section 315b as judicially reviewable. The Court of Appeals concluded that the petition was untimely, vacated the Board's decision, and remanded with instructions to dismiss. The Supreme Court held the decision is vacated and remanded. Justice Ginsburg delivered the opinion of the court. Section 314d precludes judicial review of the agency's application of Section 315b's time prescription. A party generally cannot contend on appeal that the agency should have refused to institute an inter partes review. Section 314d. That follows from Section 314d's text and Cuso Speed Technologies versus Lee. In Cuso, this court explained that Section 314d precludes review of the Patent Office's institution decisions, at least where the grounds for attacking the decision to institute inter partes review consist of questions that are closely tied to the application and interpretation of statutes related to the Patent Office's decision to initiate inter partes review. The question here is whether a challenge based on Section 315b ranks as an appeal of the agency's decision to institute an inter partes review. Section 314d. There is no need to venture beyond Cuso's holding that Section 314d bars review at least of matters closely tied to the application and interpretation of statutes related to the institutional decision. A Section 315b challenge easily meets that measurement. Section 315b, setting forth a circumstance in which an inter partes review may not be instituted, expressly governs institution and nothing more. This conclusion is strongly reinforced by the statute's purpose and design. Congress designed inter partes review to weed out bad patent claims efficiently. Allowing Section 315b appeals, however, would unwind agency proceedings determining patentability and leave bad patents enforceable. In Click-to-Call's view, Section 314d's bar on judicial review is limited to the agency's threshold determination under Section 314a of the question whether the petitioner has a reasonable likelihood of prevailing. Cuso is fatal to that interpretation, for the court in that case held unreviewable the agency application of a provision other than Section 314a. Contrary to Click-to-Call's contention, Section 314d's text does not limit the review bar to Section 314a. Rather than borrowing language from related provisions that would have achieved Click-to-Call's preferred meaning, Congress used broader language in Section 314d. Click to Call also insists that Congress intended judicial supervision of the agency's application of Section 315B, but the statute instead reflects a choice to entrust that issue to the agency. Finally, SAS Institute versus Iancu offers Click to Call no assistance. Unlike the appeal held reviewable in SAS, Click to Call's appeal challenges not the manner in which the agency review process once instituted, but whether the agency should have instituted review at all. Click to Call argues in the alternative that its Section 315B objection is authorized as an appeal from the board's final written decision, which addressed the Section 315B issue. Even labeled that way, Click to Call's appeal is still barred by Section 314D because Click to Call's contention remains essentially that the agency should have refused to institute inter partes review. The decision below is vacated and remanded. Justice Ginsburg delivered the opinion of the court, in which Chief Justice Roberts and Justices Breyer, Kagan, and Kavanaugh joined, and in which Justices Thomas and Alito joined except to as Part 3C. Justice Gorsuch filed a dissenting opinion, in which Justice Sotomayor joined as to Parts 1, 2, 3, and 4. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at rhodesscholar80@gmail.com. That's ROADS and 80, or on Twitter at Court Syllabus.